The moment that changed my career happened on a quiet Tuesday morning in January. I knew something was different the second my courtroom doors opened. Federal security entered first, metal detectors, security screens, bomb-sniffing dogs, not because of a threat, but because of who was arriving. Then he walked in, 19 years old, nearly 7 feet tall, wearing a tailored designer suit that cost more than most people's monthly salary. He was the son of a former United States president, raised around power, protected by influence, and walking with the confidence of someone who had never been told no. Behind him stood 4 federal protection agents, 3 attorneys, one of them a former solicitor general, 2 assistants carrying leather briefcases that probably cost more than my first car. He didn't look nervous. He looked entitled. And his expression told me he believed this case would end the way most things in his life had ended, quietly, comfortably, and without consequences. But sitting in the front row of the gallery was someone else. Someone with no security detail, no expensive lawyers, no influence. David Morales, 52 years old, high school history teacher, father of 2 college students. His glasses were taped together, broken 2 weeks earlier. Fading bruises marked his face, and his eyes carried the fear of a man who had been hurt, then warned not to speak. The charges were serious: assault and battery, underage drinking, use of a fraudulent ID, and witness intimidation. According to police reports and security footage, the defendant had entered a 21-plus nightclub using a fake ID. When Mr. Morales accidentally bumped into him near the bar, words were exchanged, then hands. The defendant grabbed him by the collar, shoved him into a wall, knocked his glasses off, and threw him to the ground. And then came the words that turned this case into national news. "Do you know who I am? My father was president. One phone call, and your career is over." Those words weren't shouted in anger. They were spoken with confidence, the confidence of someone who believed power was inherited. What happened next didn't just shock the courtroom. It tested whether the American justice system could stand up to political legacy, and whether the law still meant what we teach our children it means. If you believe no family name should place someone above the law, if you believe threatening citizens with political power is an attack on democracy, then stay with me. Because what happened next proved that justice still works when judges do their job. I took my seat and looked across the courtroom. The security presence was impossible to ignore. Agents lined the walls. 2 stood near the door. One positioned himself directly behind the defendant. I addressed the lead attorney. "Counselor, before we proceed, explain to the court why your client requires this level of federal protection." The attorney stood slowly, gray hair, perfect posture, a man who had argued before the highest court in the country. "Your Honor, my client receives protective services due to his status as the child of a former president. This protection is authorized and ongoing." I nodded. "Your client is 19 years old, an adult. Explain why this protection extends into this courtroom." "Your Honor, protection continues unless declined. My client has not declined it. Additionally, there have been threats connected to this case." I looked toward the gallery. "Threats from whom?" The attorney hesitated. "We cannot discuss specific intelligence assessments." "Of course." I turned to the defendant. "You may speak for yourself. How do you plead?" He stood, tall, relaxed, almost bored. "Not guilty, Your Honor. This is ridiculous. I'm only here because of my last name." He gestured casually toward Mr. Morales. "That guy started it. He bumped into me on purpose, probably recognized me and wanted attention." The courtroom reacted instantly. I raised my hand. "Mr. Noak, you are 19 years old. You were inside a 21-plus nightclub. How did you gain entry?" He shrugged. "Everyone uses fake IDs in college. It's not a big deal. The club didn't care." I placed my pen down carefully. "You just admitted to using a fraudulent ID." His attorney leaned toward him, whispering urgently. The defendant waved him off. "Your Honor, let's be real. This stuff happens every weekend. I reacted. That's all. I turned to the prosecution. Ms. Chen, present the evidence. She stepped forward with a tablet. Your Honor, we have security footage from multiple cameras covering the incident in full. May I play it? I nodded. The lights dimmed. The first video showed the entrance. The defendant handed over an ID. The bouncer barely looked at it, then looked at his face. Recognition. The rope lifted. The second camera showed the bar, crowded, loud. The defendant gesturing wildly, holding a drink. The third camera showed the incident, a small bump, an apology, then sudden aggression, hands on the collar, a shove into the wall, glasses flying. Mr. Morales tried to walk away. The defendant followed. Another shove. Mr. Morales hit the floor. Then the audio came through, clear as day. My father was president. One phone call and you're finished. Nobody messes with my family. When the lights came back on, no one spoke. I looked at the defendant. Do you still claim self-defense? The courtroom stayed silent. Silence has weight. I turned to the defense table. Counselor, would you like to revise your position? The attorney stood quickly. Your Honor, my client is a young adult who made mistakes. The use of a fake ID is a minor offense. The altercation occurred in a crowded environment. Words spoken in the heat of the moment should not be treated as criminal threats. I looked at him. Counselor, threats don't become harmless because they're spoken loudly. I turned to the gallery. Mr. Morales, please come forward. He rose slowly. A man who spent his life teaching teenagers suddenly standing in front of them. Except today, the lesson wasn't history, it was courage. He raised his right hand and was sworn in. Tell the court what happened. His voice was steady but soft. Your Honor, I've been a public high school history teacher for 26 years. I was at the club that night for a colleague's retirement. I don't go out much. He paused. I was walking back from the bar. The place was crowded. I bumped into him by accident. I apologized immediately. His eyes dropped briefly. That's when he grabbed my shirt and shoved me into the wall. A murmur moved through the room. I tried to walk away. I didn't want trouble. He followed me, knocked my glasses off. I need them to see. Then he pushed me to the ground. He swallowed. But what scared me wasn't the physical part. I leaned forward. What scared you, Mr. Morales? He told me his father still had power. That one phone call could end my career. That I'd never teach again. His voice cracked. I teach American history. I teach my students that no one is above the law. That night I thought maybe I was wrong. The courtroom was frozen. After that night, he continued, I started receiving phone calls, unknown numbers, people telling me to drop the charges, telling me school boards are political, that teachers are replaceable. I turned to the prosecutor. Ms. Chen? She stepped forward. Your Honor, Mr. Morales recorded 2 of those calls. She pressed play. A distorted voice filled the courtroom. You should think carefully. Powerful families don't forget. Careers end quietly. A second recording followed. This is your last warning. Drop the charges. The room reacted instantly. Gasps, anger, whispers. I looked directly at the defendant. He wasn't watching Mr. Morales. He was scrolling on his phone. I raised my voice for the first time. Mr. Koch put the phone away. He looked up, annoyed, and slowly pocketed it. Mr. Morales, I said, why are you still here? He met my eyes. Because if I don't stand up, I can't face my students again. I leaned back in my chair. I had heard enough to know what this case was and what it was not. I turned to the defense. Counselor, your client just listened to a teacher explain how he was assaulted, threatened, and pressured into silence. Do you still maintain this was a misunderstanding? The attorney adjusted his tie. Your Honor, emotions are running high. My client has lived under extraordinary circumstances his entire life. Constant security, constant threats. That environment shapes how one reacts. I nodded slowly. Pressure explains behavior. It does not excuse it. I turned to the defendant. You've had every advantage life can offer. Protection, education, opportunity. Tonight, I want to know something simple. I paused. Do you understand why Mr. Morales was afraid? He smirked. I mean, people say things. I didn't actually do anything to him after. The room reacted instantly. I raised my hand. Mr. This is not social media. This is a courtroom. I looked him directly in the eyes. When someone invokes political power to threaten a citizen's livelihood, that is not talk. That is intimidation. The prosecutor stood. Your Honor, the state would like to address the witness intimidation charge directly. Proceed. She faced the court. The defendant did not merely make a statement. He made a promise. That promise was reinforced by subsequent anonymous calls. Whether or not he personally placed those calls is irrelevant. I nodded. Intimidation doesn't require follow-through. It requires fear. I turned back to the defendant. You told a man his career could be destroyed with a phone call. Do you deny saying those words? He hesitated. I was angry. I didn't mean it literally. You didn't need to. His attorney stood abruptly. Your Honor, we are prepared to file a motion claiming selective prosecution. These charges are unusually severe for a 19-year-old college student. I felt my patience thinning. Counselor, your client is 19, an adult. Adult actions receive adult consequences. The defendant leaned forward. This is political. Everyone knows it. I leaned forward too. No, this is personal responsibility. I gestured toward Mr. Morales. That man teaches children what democracy means. You taught him fear. The courtroom was silent. You thought your last name could end this case. I paused. It cannot. I took a moment before speaking, not for hesitation, for precision. When courts rush, I said, mistakes happen. This court will not rush. I reviewed the file once more, even though I already knew it by heart. Then I looked up. Based on the evidence presented, the court makes the following findings. The defendant straightened in his chair. For the charge of assault and battery, I paused. The video evidence shows unprovoked physical contact initiated by the defendant. The victim attempted to disengage. The defendant escalated. I looked directly at him. That charge is sustained. A murmur moved through the gallery. For possession and use of a fraudulent identification. I continued. The defendant admitted on the record to using a false ID to enter a restricted establishment. Another pause. That charge is sustained. His attorney lowered his head. For underage consumption of alcohol. The footage shows the defendant consuming alcohol inside the club. Sustained. The room was holding its breath now. And finally, I said, witness intimidation. I leaned forward slightly. The defendant explicitly invoked political power to threaten a citizen's career. That threat was credible. It created fear. Subsequent calls reinforced that fear. I let the silence do its work. That charge is sustained. The defendant's face flushed. This is unbelievable, he muttered. I raised my hand. You'll have an opportunity to speak. For now, listen. I turned to the defense. Counselor, you argued selective prosecution. Let me be clear. I looked back at the defendant. This court does not punish family names. It punishes conduct. I shifted my gaze to the gallery. If the defendant were anonymous, the outcome would be identical. I closed the file. The court now moves to sentencing. The defendant finally looked uncertain. I addressed him directly. You grew up surrounded by power. That is not your fault. I paused. What you did with that power, that is. I glanced at Mr. Morales. You assaulted a teacher who serves this community. You attempted to silence him. You showed no remorse. The defendant's attorney stood. Your Honor, we request leniency. My client has his entire life ahead of him. I nodded. So does every victim. The courtroom was silent. Sentencing will reflect accountability, deterrence, and the protection of the public. I took a breath, and then I spoke the words he never expected to hear. I spoke slowly, not for effect, for clarity. Sentencing is not revenge, I said. It is responsibility. I looked directly at the defendant. For the charge of assault and battery, the court sentences you to 6 months in state custody. A wave of shock moved through the room. The defendant's attorney stood instantly. Your Honor, I raised my hand. Sit down, counselor, I continued, for the charge of witness intimidation. I paused. An additional 12 months to be served consecutively. The defendant's face drained of color. For possession of a fraudulent ID and underage consumption of alcohol. An additional 6 months. The courtroom was frozen. Total sentence, 2 years. The defendant slammed his hands on the table. You can't do this. I'm in college. I met his eyes. College is a privilege. Accountability is a requirement. His attorney shouted, "This is excessive. We will appeal immediately." "You are entitled to appeal," I said calmly. "You are not entitled to immunity." The defendant turned red with anger. "This is because of my family. You hate my father." I leaned forward. "No, this is because you believed your family exempted you." I turned to the clerk. "In addition, the defendant will pay full restitution." I listed it carefully. Medical expenses, replacement eyewear, pain and suffering. Total, $25,000. I looked at the defendant again. "A protective order is issued. You, your family, and anyone acting on your behalf will have no contact with Mr. Morales." The defendant laughed bitterly. "This isn't over." I met his stare. "Every defendant says that." I raised the gavel. "Mr. Ree, you grew up in the shadow of power." I paused. "But power without discipline becomes danger." I brought the gavel down. "Bailiff, take him into custody." The sound echoed. Federal agents moved instinctively. Handcuffs clicked. The tallest defendant I had ever sentenced stood in disbelief. As he was led away, he turned back. "You'll regret this." I spoke one final time. "Threaten this court again, and you'll leave with more time." The doors closed, and the room exhaled. By the time I returned to my chambers, the story had already left the building. News alerts lit up phones. Headlines raced ahead of facts. Opinions formed before transcripts were read. Within hours, the case was everywhere. Cable news panels debated whether the sentence was fair. Commentators argued privilege versus accountability. Legal analysts replayed the security footage frame by frame. The defendant's family issued a statement. They called the ruling excessive. They called it political. They called it unfair. An appeal was filed the same day. I expected that. Every defendant is entitled to one. But what followed surprised even me. Teachers' unions across the state released statements supporting Mr. Morales. Letters poured in from educators who said they had felt pressured before, not by presidents, but by power. Parents wrote about teaching their children that rules matter. Veterans wrote about serving a system where no name outranks the law. Mr. Morales returned to his classroom. On the first day back, he told his students the truth. That standing up is frightening, that consequences are real, but that principles only survive when someone defends them. Meanwhile, the appellate court reviewed the case. They reviewed the footage, the statements, the intimidation evidence. 8 weeks later, their ruling arrived. Unanimous. The sentence was upheld. The opinion was brief but clear. The defendant's status as the child of a former president does not reduce criminal responsibility. The sentence reflects the seriousness of using political influence as a tool of intimidation. The defendant served his sentence, no special treatment, no private wing, no exceptions. And slowly, the noise faded. But something else remained, a reminder that justice does not announce itself loudly. It does not chase approval. It stands quietly, waiting for the moment it is tested. People often ask me what cases stay with me. It's never the loud ones. It's the quiet moments, when the law is tested not by chaos, but by confidence. Confidence that rules don't apply. Confidence that influence will smooth consequences. Confidence learned, not earned. This case was never about politics. It was about belief. The belief that power transfers through bloodlines. That assumption is dangerous, because democracies don't collapse overnight. They erode when exceptions become normal. I thought often about Mr. Morales, a man who teaches young people that our system works only when ordinary citizens trust it. Trust doesn't come from perfection. It comes from consistency, from knowing that when you stand in a courtroom, your last name stays outside. The law doesn't care where you grew up, who your parents are, or how powerful your connections may be. It cares about conduct. That lesson matters now more than ever, not because of one family, but because of the idea that anyone might be untouchable. I've sentenced people from every background imaginable. Some arrived in designer suits, some in borrowed clothes. Inside the courtroom, it never mattered. Justice only works when it applies equally, especially when it's uncomfortable. I didn't enjoy imposing that sentence. No judge enjoys ending a young person's freedom. But accountability early is mercy later. If privilege is never challenged, it hardens, and hardened entitlement becomes harm. This case reminded me why courts exist, not to satisfy public opinion, but to protect principle, quietly, relentlessly. Before I leave the bench each day, I remind myself of one simple truth. A courtroom is not a stage, it's a promise. A promise that when someone walks through those doors, frightened or confident, powerful or ordinary, the law will meet them the same way. This case tested that promise, not because it was complicated, but because it was tempting to soften, tempting to simplify, tempting to treat power as a reason to hesitate. But justice cannot hesitate. If it does, it stops being justice. I thought about the thousands of people who would never step into a courtroom with cameras outside. Teachers, workers, parents, people who follow the rules because they believe the rules protect them. They deserve to know the system holds, that threats don't win, that names don't outweigh conduct, that influence does not replace responsibility. The defendant walked into my courtroom believing his family's history would carry him through. What carried him out was something stronger. The law. Not angry, not political, not personal. Just firm. That is how justice survives. Quiet decisions, consistent standards, and judges willing to say no when it would be easier to say yes. If this story reminded you why the rule of law matters, why accountability must be equal, and why democracy depends on restraint, then stay with us. Subscribe for courtroom stories that focus not on spectacle, but on principle. Because justice doesn't need applause, it only needs courage. And in that courtroom, on that Tuesday morning, the law did what it was meant to do. It stood.